Okay, so thanks everybody for coming. We're going to be talking a little bit about some of the options and information that are available to your clients once they have been granted asylum. And we're recording at least the beginning part of this just so that we're able to then share it on Teachable and share it with others, but we'll turn off the recording and let you guys ask questions. So Chelsea and I are going to go through this quick presentation. It shouldn't take a whole lot of time, and then we'll be available to answer any questions and also as well to field any questions about ongoing asylum cases. So, but as many of our pro bonos have started, including some of you have started getting approvals or are close to getting approvals, we hope, on your clients' asylum cases, we thought it might be helpful for us to talk through kind of what are the next steps. We do understand that, of course, through VECINA, we had only asked you to represent your client through the approval of their asylum or the final decision on their asylum application. Some of you may decide to take on representing your clients with further steps. Some of you may not. Either way is fine, but you may really want to be able to explain some of these things to your client, even if you're not providing any further assistance or representation. Your clients may well have questions about all of these things. So we're going to be talking about first, I'll just talk a little bit about kind of what is asylum, what it is and what it isn't. And then we're going to be kind of talking about some of the next steps and some of the things that are available. So asylum is granted indefinitely. So there's no end date on an asylum grant. So if your client has been granted asylum, they have been granted asylum for an indefinite period of time. But that's not to say it can never be ended. It can. Asylees actually can be ordered removed from the US. Usually that's because they were convicted of any number of different crimes in the US. That's usually going to be the reason. The most permanent possible status you can have in the US from an immigration perspective is US citizenship, where you're not subject to immigration laws and being removed from the United States. So we'll talk in a minute about like what your client's pathway to US citizenship is, but unless your client becomes a US citizen, there always is the possibility of being removed from the United States. So just something to know. On the other hand, again, asylum is generally not going to be ended unless somebody is ordered removed. If USCIS wants to rescind someone's asylum because they think there was maybe fraud in the underlying application, that's pretty unusual. But again, the most permanent possible status your client can have is US citizenship. So if your clients intend to stay permanently in the United States, that's a really good option. And heck, even if they don't, because once you're as a US citizen, you can go live anywhere you want in the world and you're never going to lose your US citizenship. I think that you all probably know that we have in our Teachable course a letter that you can give to your clients once they've been granted asylum, kind of outlining, in a sense, everything that Chelsea and I are going to talk about today. So that's a really helpful resource to give to clients so that they kind of understand what their status is and what their next steps might be. The grant definitely opens doors to immigration benefits, including applying for a green card and also applying for their spouses and children to get derivative asylum status, which I think is probably top of mind for anyone whose family is outside the United States. So let's go to the next slide, if you don't mind, Chelsea. So I'm going to turn it over to Chelsea to talk about another important question that may come up, which is, can I travel outside the United States now? And if so, how do I do that? And, what are the things to be aware of?
Yeah, so generally the answer is yes, your client can travel, but they need authorization to leave the US. So I know that probably for many of them, they have been longing to travel, not necessarily to Afghanistan, but maybe to other countries to see other family members. So now they're able to do that, but they must have authorization to do that. And so the steps for that, to obtain that authorization, are to complete the Form I-131. Now, that form may sound familiar because some of you all may have just submitted it for reparole. It is the same application. The form was actually updated in order to include the re-parole process for Afghans as of June of this year. But before that, one of the purposes for it has always been for travel authorization, whether for asylees, for legal permanent residents, or others in other types of immigration statuses. So that form must be not only filed for, but also approved, and then they will receive a travel document after the approval. And that document is what they will need to travel outside the US. So a few important notes to consider and just to remember and to notify your clients about is that, one, they cannot travel on their Afghan passport. It basically would be seen as them availing themselves to like the protection of Afghanistan, and that's an issue for asylees who just claim that this country provides or presents some type of danger to them. So we don't want them to use their passports for the travel, or to apply for a new Afghan passport, even if they're not going to Afghanistan to get that new passport, even if they're going to, the local embassy or consulate here in the US or to another country, they do not need to apply for that passport from Afghanistan. This travel document will be sufficient for them to travel and return to the US. Also, and many of you probably know, but your clients, you just need to remind them, they do not need to travel to Afghanistan. They must not. And that's because, again, they just claimed and won asylum from this country. If the US government notes and sees like on their passport travel records that they've traveled back to Afghanistan, then the government may take it as they no longer have the fear of returning to that country, and therefore it could invalidate their asylum status and they can lose asylum status. That is a very real possibility. So therefore, we usually encourage clients to not travel back to Afghanistan unless and until they become a US citizen, if that's something they desire and are eligible for. So even if they do become a legal permanent residents in another year or two down the road, they really should hold off on returning to Afghanistan, if at all. But if they do desire to return to Afghanistan, they need to wait until they become a US citizen, because again, at any point in time until that citizenship status is obtained, the US government can always look at their history and their actions and decide to strip away their asylum status, which would then, again, if they're applying for adjustment of status based on that asylum application, it could strip them of all of their protections here in the state. So this, again, is just to protect them. I know that they have many family members who are there and they're trying to get back to them. We understand that, and we are going to talk about some possible family reunification options for them, but we just want to make sure your client is protected at all costs. So also with work authorization, that's something else that we want to just touch on quickly. So your client, the minute that they receive their asylee status, they are able to work incident to that status. They technically don't need some type of documentation like the official EAD to work. However, it's probably helpful for them to have it, whether it's for driver's licenses or other things. And most likely employers may still ask. I mean, they are still eligible to work, but if they just feel more comfortable having EAD, which of course is no issue, they need to basically apply for a new EAD, but it would be under category A5 instead of the C8. So the C8 category, if those of you have applied for it or will be applying soon for that, that's for if you have a pending asylum application. Once you become an asylee, you're no longer eligible for that C8 EAD. That also means that now you must pay a filing fee, because now basically those filing fees and all of that kind of come into play now that you have been here for a while. You're able to provide now for yourself and your family. You're also able to apply for an unrestricted, or your client's able to apply for unrestricted Social Security card. This again is just kind of a benefit with them moving forward with life and applying for other types of like benefits and just other things establishing their life here in the US. It's very helpful for them. And they will do that directly with the Social Security Administration. So I believe, and they'll need to like go to their local office, but I believe what they'll just basically need is like proof of their asylum grant and obviously their old Social Security card. And then that way the asylum or the Social Security Administration in that office, they're very familiar with this process. So they'll be able to tell them what to do. But right now your client's Social Security card probably has like work only type of stamp or something wording on it, that would just basically be removed. And yeah, just to show that they're in a new immigration status. All right. So I'll let Jennie talk about some of the OR benefits.
Yeah, thanks so much, Chelsea. And just one other note about the Social Security card. Once your client gets that restrictive language, like as Chelsea said, like it says on their cards right now, like authorized for work only with DHS authorization or something, like they're now eligible as asylees to get that language taken off. Like if you look at your own Social Security card, it probably doesn't say that. And once you have that unrestricted Social Security card, you then don't have to, again, asylees don't have to have that EAD work authorization card from USCIS in order to be eligible to work. They would just need to be able to present like their unrestricted Social Security card and say a driver's license or a state ID. If employers demand an EAD, that's actually technically against the law if asylees can otherwise fulfill the requirements of the I-9 form. And if you do have clients that run into employers who demand EADs from your asylee clients, like there's actually an office at the Department of Justice that is charged with making sure that employers don't do that and can potentially help out. And I'd be happy to connect any of you with them. They have a hotline that workers and employers can call to try to sort through those things, because it is often that employers think they have to have an EAD from someone who's not a citizen, but that's not necessarily true. And it's definitely not true for asylees who are going to have that unrestricted Social Security card. Some other benefits to be aware of for your client who's granted asylum is that probably all of your clients have already gotten government benefits through ORR, the Office of Refugee Resettlement, when they arrived here as parolees, because Congress had allocated all this money for Afghan evacuees to be getting various government benefits. Asylees are entitled to various government benefits. So your clients may be eligible for more or different government benefits like health insurance and maybe other things through the Office of Refugee Resettlement once they've been granted asylum. I can't really speak anymore to like exactly what that might be, but essentially the message here is like, if they have any kind of need for benefits at this point, they should speak with their local refugee resettlement agency, because those are the folks who are charged with administering all those things for asylees. So your client can let them know, like at this point, I was a parolee, now I've been granted asylum. What else am I eligible for? And I would say generally it's a good idea for your client to go as soon as they can after being granted asylum to their local resettlement agency to look into what benefits they might be eligible for as asylees. And I think, yeah, Chelsea is going to talk now about family reunification pathways for asylees.
So, yeah, we just wanted to talk about a couple of pathways. Again, for options for your clients. Again, we're sure that many of your clients, I mean, especially working with your cases, but many of your clients have family that are still overseas, whether in Afghanistan or in other countries. And fortunately, depending on the family member, there are options available for them to be reunited here in the United States and receive the same protections that your client is currently receiving. So there are two different pathways we'll talk about today. I-730, which you've probably been hearing a lot more about recently. And so, you're whether or not through your client or through conversations with Jennie or I. So we want to just give you a little bit more detail about that. And then there's also this option. There's no formal name for it, but it's the P3 category of the U.S. Refugee Admissions Program. slash affidavit of relationship. It's something that you have to file, and Jennie will definitely give a lot more information about that. But we just want to at least make you all aware of this. Again, whether or not you're applying for this on behalf of your client to continue representation, or just at least to be able to have some background knowledge in case your client wants to ask you a few questions before you end your representation, or like right after you're ending your representation. So with the I-730, so this is a path of family reunification for their family members, for those who are located overseas, and it can be used by both asylees and refugees. What we're talking about today is mainly asylees, because that's all we've been working with, are those who are applying for asylum, but who can apply for this petition on behalf of their family member isn't a refugee or an asylee. Asylee, just to make sure everyone's on the same page, an asylee means that you have an approved I-589, which is an application for asylum. Not a pending one, not that they plan to file, but once they receive that official approval by USCIS, or if they happen to be in court by the US immigration court. But once they receive that particular status, then they're able to file an I-730. And then just discussing who are the beneficiaries. So it is their spouse or their unmarried children under 21. So spouse means that they had to have been legally married to them at the time of the asylum grant. The child means that they were under 21 at the time of the I-589 and that they're unmarried. So we say that because there may be the case where your client, say, files today and their child is 20 years old, but they don't get, they become 21 next month and the asylum is not granted until next May. That doesn't bar them from being able to be considered a child under this status. And so they are able to have that protection, which is also why it's important, just looking at when you're filing the asylum, you try to get as many family members included as derivatives on the application as possible, because it really does carry over and they are protected under that asylum filing. So just kind of the general steps for this pathway is that they would file the I-730. Then once that's approved, they file the I-730 with USCIS. Once that's approved, the National Visa Center, also known as the NVC, you may have heard us mention it once or twice, but there is going to be some documentation that your client would need to upload and give to them for review to make sure that, this is their spouse, this is their child, that your client is an asylee, just to make sure that they're not necessarily just allowing any and everyone to come over through this petition. And then once that is documentarily qualified, that case with the NVC, then they would be scheduled for an interview by whatever U.S. embassy or consulate is available to them. And where that's located, that is a very big question that many of us advocates and practitioners are trying to figure out. A lot of it's going to just be based on what location is available for your client to go to, or your client's family members to go to safely. And that decision doesn't necessarily need to be made when you're filing the I-730. The important thing is that the I-730 is filed, it's pending, it gets approved. By the time it gets to that interview process, they can kind of figure out where they are able to go to safely for that interview, or just to conclude that process. So just discussing when your client can apply for their family members. So they actually have a limited time frame. They're only able to do it within the 2 years immediately after their I-589 is approved. So with this, we really encourage your client to file as soon as possible. And that's just because, things may continue, life may continue, and 2 years can go by quicker than you would think. And we just don't want them to fall into the issue where now they're basically trying to beg to make sure that their application is going to be approved or accepted by USCIS and the NVC and all of that. And we also want to make sure that, that the I-730 process can take several years. Don't want to scare anyone off for the clients, but we've been hearing some estimates of at least 3 years, if not more. I mean, we do think that, or we do hope that the process will be sped up for Afghans, especially those who came through this OAR OAW process. But we're not exactly sure at this point. What we can kind of foresee is the I-730 being approved or filed and approved, and then getting to the MVC stage. But after that, we're seeing quite a bit of a slowdown. We'll also say the I-730, although it's been an existing pathway outside of the Afghan context, it's not the most common application. And I think because of that, our US government is quickly training a lot of their staff and creating new positions and openings for officers to be able to do these applications, because we're going to be seeing over the next couple of years that they're going to start to receive thousands of these. So because of that, we just think we're probably a little bit further ahead than probably USCIS or the State Department is for these applications. But all of that to say, just tell your client to file as soon as possible, because we definitely want, them to be reunited with their spouse and children as soon as possible. And then now Jennie will share more about the other pathway.
So this is a pathway that's less certain than the I-730 pathway, where your client's family members would be coming to the US as derivative asylees. Really, it's, for those of you who represented large families in the US where you had one principal applicant and then the relatives were derivatives, it's the I-730 process is really kind of an extended way of doing the same thing that you did there. This is a different pathway. There is a way for asylees to ask for certain family members to be considered for the US refugee program. And that really is for asylees to kind of identify to the government, like, hey, I have these family members who are in danger. Please let them be considered for the US refugee program. And that would mean that those family members generally have to be outside their country of origin and would be able to prove their own refugee claim. So establish their own well-founded fear of persecution. And they would kind of go through a refugee interview overseas that's in a way very similar to what you did in the asylum process, although with a lot less, there's definitely a much lower requirement in terms of evidence, because almost no refugees have representation during this process. So the way to really the only entities that can get this process started is a refugee resettlement agency. And really the most important reason that I mention this is because asylees can identify their spouses and children for this, but they can also identify their parents. And that's I know that there are many Afghans who are worried about trying to get their parents out. And so this is one possible pathway for that. So if your client is worried about their parents, I would encourage them to go talk to their resettlement agency to see whether this affidavit of relationship might be a possibility. And again, it's only refugee resettlement agencies that can file these. Immigration lawyers can't do them. They have to be done by the refugee resettlement agency. Otherwise, people who are worried about their parents, really the only other way to petition for your parents is for your client to become a US citizen. Once you're a US citizen, you can file a family-based petition for your parent, and it's actually a pretty quick process at that point. Your parent is what's called an immediate relative, so there's no years-long wait for a visa for them. But there's going to be quite a few years before your client can be a US citizen. But again, once your client is a US citizen, there is a pathway for them to then, reasonably easily bring their parents here to the United States with a green card. One other thing that I also just wanted to mention, because it may be in some of your minds in this topic of family reunification, was that form from the State Department, the DS 4317. I don't know if all of you remember that. I know it's something that we encouraged all of our pro bonos to do for their clients when they first came out with this form more than 6 months ago. Again, the title is the DS 4317, and it's a way that Afghan parolees could identify to the State Department that their spouses and children overseas were in need of relocation to the United States. So some of you may have had your clients already fill that out. How does this intersect with this whole I-730 process? kind of unknown. I've asked that question in meetings with government officials and sort of not gotten the clearest answers. And I think the answer is probably like, you should try all the options. That's what I'm doing for my own clients. Like, I would definitely, I think it's good to have tried both things and see which one works or works more quickly. But it's not completely clear at this point. Like if they put how those two processes might intersect, if at all. So if and when we learn more about that, we will share it out with all of you. But I think for now, the message is like, I would try both the DS 4317 and the I-730. I would file both of them. And then I think our final topic, I'm just going to talk a little bit about something called adjustment of status, which is something that is available to anyone who's granted asylum. That is an application to become a lawful permanent resident, known familiarly as a green card. So to get a green card in the United States, you have to have a special legal pathway open to you, and asylees and refugees have a special pathway to lawful permanent residence. The process of becoming a lawful permanent resident in the United States is known as adjustment of status, or just adjustment. The good thing, one of the good things about the asylee and refugee pathway to adjustment of status is that it's like one of the easiest ways. Some of the other pathways have some more restrictions on them and kind of complications that can get in the way. And it's really, the asylee refugee pathway is one of the most forgiving pathways to adjustment of status. Becoming a lawful permanent resident is generally going to be a very good idea for asylees. It just provides another layer of protection in the United States, and it is required in order to become a US citizen. So in order to naturalize and become a US citizen, you first have to be a lawful permanent resident for a certain number of years. For asylees, that's 4 years. And generally the requirement is 5 years, and that's true for asylees too, but the difference here is when you get your green card as an asylee, it's actually backdated a year. So it's like when they give you your green card, you already had a green card for a year under the law. So 4 years after, as an asylee, you get your green card, you can apply for US citizenship. There's a form that's required for the process, the form I-485. It is a long form, but it's a much easier process overall than applying for asylum. The interesting question here really is like, when can you apply? So the sort of interesting wrinkle lately on this is there's a legal requirement that for USCIS to approve an asylee for a green card for adjustment of status, the asylee has to have been physically present in the US for 1 year at least after the grant of asylum. And so until now, they wouldn't let you even file your adjustment of status until you've been physically present for a year, but they changed their policy earlier this year. And asylees can now file for adjustment of status before they've been physically present for a year. That said, like, I think it probably doesn't make sense to do it right away for this reason. They can't approve the application until the asylee has been physically present for a year. And they generally want to have some kind of proof that your client has been physically present for a year. So I think there's a chance that if you file like a week after getting asylum, that like a year or more down the line, you'll get a request for evidence of physical presence. So it probably makes sense to wait at least 6 months, but sort of TBD, because like this policy hasn't been around long enough for us to see how it's going to play out. So that's just kind of our guess on this. You're actually allowed to file for adjustment of status right away if you so choose, or you can wait a little while. There is a fee for it, and it is quite expensive. It costs over $1,000. Asylees can get a fee waiver, but you have to apply for a fee waiver, and only certain people can are eligible for a fee waiver. Generally, if you are receiving means-tested public benefits, or your income is at or below 150% of the federal poverty guidelines, or if you have some kind of extreme financial difficulties. Other people are not going to be eligible for the fee waiver. So some people may be needing, especially with large families, to kind of save up money to pay for those adjustment of status applications. So in part because of that fee, it might be a good idea to like talk with your clients about this and let them know that that's coming so that they can start planning for what that might look like. And if they might need to pay fees, that they're going to be able to start saving up the money for that. Because it's a really important thing to do. I would say I would strongly encourage clients to be applying for permanent residence and then eventually for US citizenship. Because again, the only way to guarantee that immigration can never remove you from the US is to become a US citizen. That is by the most permanent way to stay in the United States, but it is a pathway that is open to anyone granted asylum. So I think that's the end of our slides. So I'm going to actually turn off the recording here and then open the floor up for questions from everyone.